Hello everyone, my name is Luciano Oliveira. I'm a Brazilian attorney, also licensed in Texas and California. And today I'm going to answer this question. Is it possible to renounce my share of an inheritance in Brazil? And the short answer is yes, it is well possible. However, just like pretty much everything in Brazil, there is much more red tape and bureaucracy than you would expect. The most common approach is for a formal procedure to be filed with a court. So the first point here is that there should be a probate in place. You can't just send a letter to a Brazilian court saying, well, I don't have any interest, goodbye. If you do so, this is not going to have any legal effect whatsoever. So the first step would be for a probate to be started, and this probate is usually started by one of the local heirs, if any, in Brazil, and then probably through communication from this local heir with you, there would be a request, in case you don't want to participate in the probate, of course, for you to renounce your share into the probate so the probate can proceed. I think this is a pretty important point that most people do not understand because of the dynamics of a probate in Brazil. If you don't formally renounce your share, you kind of make this probate to get stuck, and this could take literally years until they can overcome the lack of representation or renunciation by some of the heirs. So again, you need a formal procedure for that. And there are very specific steps that you're going to need to follow in order for your renunciation to be accepted by the Brazilian court. More specifically, you will need to present paperwork first to identify yourself. And unfortunately, from the Brazilian perspective, there is no identification, proper identification, unless the Brazilian system, the Brazilian legal system knows your parents' names. Meaning, just from the get-go, you're going to need to have a birth certificate that's going to be apostilled in the United States, sent to Brazil for sworn translation and recording in a specific type of registry. And the birth certificate is usually just the beginning. So let's talk about the challenges of getting this renunciation done. The renunciation, when done in Brazil by a Brazilian, is done through what we call an escritura pública, meaning that it is done through a very specific type of document that is usually done in a registry. However, for a foreign citizen who's not in Brazil, there is no such route. So usually the foreign citizen is going to need to get a power of attorney for someone to renounce on their behalf in Brazil. In other words, they are renouncing themselves, but they need someone in Brazil to make this formal in accordance with the Brazilian rules. Additionally, in theory, you cannot disclaim assets if you don't have a Brazilian ID. So believe it or not, many judges, in order to allow you to renounce your share of the inheritance, they are going to make you get a Brazilian ID for this purpose. Even though it's not that difficult to get such Brazilian ID, in theory you could get it from any consulates abroad. It's still very cumbersome and burdensome on the foreign citizen who's trying to disclaim an inheritance share to make them to get the Brazilian tax ID. Now, what is more surprising to foreign citizens is that even for you to disclaim an inheritance share, you're gonna need to have your spouse, of course, if you have one, to participate in the procedure as well. Because again, for us Brazilians, a spouse may have an interest in our claim to an inheritance. So guess what? You're not gonna be able to renounce to the inheritance share unless your spouse follows along. And yes, your spouse is also going to need potentially to get the Brazilian tax ID known as a CPF, get a birth certificate, and now there is one more step. Your marriage certificate is going to need to be validated to be presented in Brazil. Now, you're probably thinking like, should I go through all this trouble? Maybe I just ignore this thing altogether. If you do so, there are serious consequences in Brazil and the probate. It is very common for judges in Brazil, particularly judges working with probates, to have an extremely high load of cases to handle. And usually when heirs are missing from a case, the judge will usually sit back and tell the parties to figure this out by themselves. In theory, if a judge has a valid address of a missing heir, meaning an heir who's not presenting themselves to the court, the judge could send a letter rogatory to this heir's address abroad, so the heir would receive notice of the probate and, by not taking any action, free the other heirs to proceed. However, in our experience, again, the judges will usually sit back and let people figure out by themselves, meaning the judge is not going to be chasing people abroad to send them a letter rogatory. As a result, if you don't renounce, you may be causing a delay to this probate of several years. That's usually what's gonna take to make the judge move and see that if the judge do not send the letter rogatory, this thing is gonna get stuck basically forever. And therefore, most people from abroad, most heirs from abroad, when they have any care for the local heirs, they are gonna actually go through all the trouble to renounce in order to assist with the local heirs to proceed with the probate. If you wanna make this journey easier on you, you can contact our office for a review of your case, a consultation, and additional tips on how to accomplish your goals. I hope this video was helpful. Follow us for more tips, and I see you in our next video.